It's wonderful to have this many people in person. Men have neckties on. I haven't seen this many neckties in a while. No masks, so remember, if you roll your eyes during this, we'll know you're rolling your eyes and grimacing. But whether you're with us in person or on Zoom, as Dean of the Law School, I do want to welcome you to our conference on religious freedom entitled Beyond Defensive Crouch. We're grateful to the John Templeton Foundation for funding this conference. Templeton is one of the premier foundations committed to exploring the role of religion in human interaction and social organization. Templeton's grants reflect, to quote their website, Sir John Templeton's optimism about the power of the sciences and other discovery-oriented disciplines to advance our understanding of the deepest and most perplexing questions facing humankind. And I think issues about religious liberty do indeed fit that bill. I also noted that the tagline of the foundation is inspiring awe and wonder. So we have a tall order ahead of us for the next couple of days. Our conference brings together leading religious liberty scholars nationally and beyond with diverse viewpoints. And I believe that the Scalia Law School uniquely facilitates difficult conversations respectfully, but with candor and intellectual honesty. I want to thank all of our participants for sharing your time and your insights with us. We value what each of you will bring to our dialogue. Today and tomorrow, top law and religion scholars, litigators, and policy experts will explore the goods and values that religious exercise furthers, including institutional religious exercise. How religious values might not only serve, but even better promote the values of equality, dignity, and freedom as currently articulated by the state, and how religious institutions might better understand and communicate the social worth of religion and religious freedom. I mentioned litigators, and we appreciate that tonight's cocktail reception is sponsored by Sidley & Austin, which has a prominent religious freedom practice, and we appreciate the firm buying us all a drink tonight. The George Mason Civil Rights Law Journal will publish a symposium with many of the conference's papers included in it. And we're particularly grateful to one of my colleagues, Professor Helen Alvarez, for her leadership in organizing this conference. Helen serves at Scalia Law School as the Robert A. Levy Chair in Law and Liberty. And we're grateful to our school's Liberty in Law Center for its efforts not only with this conference, but for advancing civil discourse on many subjects that have liberty at its core. Professor Joanne Koob, Director of the Liberty and Law Center, now will come to the podium. Thank you.
Good afternoon, everybody. I'd like to welcome you on behalf of the Liberty and Law Center to this conference. For those who don't know, the Liberty and Law Center is an academic center within Scalia Law School. We were established in early 2018 and work on legal issues pertaining to individual liberty, the rule of law, freedom of speech, and civil discourse. The conference today, Beyond Defensive Crouch, Religious Freedom, has been almost 3 years in the making, and we were somewhat delayed by COVID, as many things were. So I'm really excited to have it come together and have you all here today. Over the course of the next 2 days, we'll have 4 panels examining this topic from different angles. During the panel, we'll be discussing 7 papers that have been written for the conference. 1 or 2 papers will be discussed presented during each panel, and then there will be a respondent responding to each of the papers. There will also be an opportunity for the in-person audience to ask questions. The panels today, as the dean mentioned, will be followed by a cocktail reception. We hope you all are able to join us. And I'd also like to do some thank yous. First, the Templeton Foundation, of course, who made this possible. The George Mason Civil Rights Law Journal, not only for their publishing of our articles, but also for volunteering their time today. They're the helpers that you see around are all of our students. Sidley for sponsoring the conference. Helen Alvarez, of course, for her incredible work in putting this together. And then also the staff at the Liberty and Law Center, including Rosaline Rosal, who really helped pull up all the details together for this. With that, I'll turn it over to Professor Alvarez.
Greetings. So I'm going to give you a little substantive introduction to things, and then I'm going to sit over here and invite the first panel up, make introductions, and get going. I am grateful to the same groups as the Dean and Joanne. We worked really hard for the Templeton Grant, and they were wonderful to work with. The Law and Liberty Center has worked every step of the way, Joanne and Rosaline in particular. The Civil Rights Law Journal has been all over this. And Gordon Todd of the Sidley Austin Supreme Court and Appellate Practice with his generous sponsorship of tonight's social events. So let me just introduce you a little bit more to the themes. It was 3 years ago that when we sought Templeton's support for this, we asked to think aloud and through scholarship about the positive contributions of religion and religious liberty in the US at the time when even this basic premise is challenged. We wanted to think beyond an exemption strategy for preserving and promoting religious liberty, including for religious institutions. We wanted to query both free exercise and establishment clauses of the First Amendment to this end, to put more squarely within the legal debate about the meaning of the reach of both of these clauses, the positive contributions of religion and religious liberty, not only to individuals, but to the common good, to dignity, equality, peace, fairness, and freedom, while also recognizing and grappling with situations in which claims of religious liberty clash with other cherished liberties. So I'm going to give you a whirlwind of the topics that you're going to hear to whet your appetite for it. You're going to be hearing about religion's pro-social contributions, the question of whether religion is special, such that it merits the attention the First Amendment provides it, which is just a huge topic in literature today. You're going to hear about whether the Lemon test for establishment is constitutionally sound and whether it has a future, about how particular theological virtues might structure religious entities' future arguments for religious liberty in order to achieve harmonious coexistence in a truly pluralistic society, whether we are in fact experiencing a new kind of establishment and what might be done to resist it, why institutional, as distinguished from individual religious freedom, might be the more important pursuit today, and how families seeking to transmit religious faith to the next generation might overcome some hurdles that are being set up in the States. I'm sorry to report that one of our presenters on the last panel was unable to be with us, meaning tomorrow's last panel will be a bit shorter. In the papers, given the overarching themes of the conference, you're going to hear genuinely law and religion discussions, not just church-state, but law and religion, with speakers sometimes investigating particular theological positions and asking how these interact with the law as it is or should be. As the Dean said, Scalia Law is a great place to have these conversations. Our Law and Liberty Center does this, discussion over division series. We like to think that we are extra capable at this. Again, I'm really grateful for your presence, and I'm pleased that you're going to get the chance to hear new ideas about a really old, but still very important topic. So we're going to proceed to the first panel, and I'm going to ask the panelists to take their seat now. I'll get out of your seat, Jerry, and I'm going to give you abbreviated introductions because you have the speaker bios at greater length in your conference program. Okay, thank you. I'm thinking that whether you want to stand or sit to deliver your remarks, we have good sound system. I'm just going to leave it to each of the speakers. Okay, Shannon, you have a spot for me? Just making sure that Okay. So I'm going to give abbreviated introductions with private opinions appended. It's more fun. I want to highlight a few things. Professor Jerry Bradley, immediately to my right, has been professor of law at Notre Dame for 30 years now. Before that at the University of Illinois, and before that as an assistant district attorney in Manhattan. He's performed a great deal of generous service, not only to the development of modern First Amendment law for all these decades, but also to the Academy in many leadership roles, including at the Hoover Institution at Stanford and the Witherspoon and James Wilson Institutes at Princeton. Jerry's knowledge in this area is encyclopedic. The way he writes about it too, with complete freedom to deal with it. he knows everything he's juggling so easily. So it's a pleasure to read his stuff too. Elizabeth Clark is Associate Director of the International Center for Law and Religion Studies at Brigham Young Law, which is a world leader in convening critical conversations about law and religious freedom. Prior to that, she was a member of the Appellate and Supreme Court Litigation Group at Meyer Brown and Platt here in DC. She's contributed enormously to both the national and global conversations about church-state issues, including a lot from comparative law perspectives, through her many books, articles, and conferences. I have been to several conferences that her center has sponsored over the years, and people have enormous respect for the quality, the volume, and the world reach of those conferences. Shannon Minter is the legal director of the National Center for Lesbian Rights. He was lead counsel for same-sex couples in the California marriage equality case, and the center's lead attorney in the important case Christian Legal Society versus Martinez. He serves on the boards of Faith in America and the Transgender Law and Policy Institute. He's been recognized as an outstanding attorney by more than a few bodies, including at the Ford Foundation and by the California Lawyer. Shannon and I have encountered one another several times over the years in panels, and I thought of him immediately as such a terrific presenter and an interlocutor of the whole body of law that we'll be dealing with. And I just realized when I was reviewing this stuff this morning that Jerry and Shannon and I all graduated from Cornell, which must mean that something about freezing your rear end off makes you think about the First Amendment, because I just think that's, there aren't that many Cornell lawyers floating around there. Finally, Anthony Piccarello is the general counsel of the U.S. Conference of Catholic Bishops, where inexplicably he also has a second huge job, the Associate General Secretary for Policy and Advocacy, a part of the conference's executive team. He previously served on President Obama's Advisory Council for Faith-Based and Neighborhood Partnerships, as an attorney for one of the premier religious liberty law firms in the nation, the Beckett Fund. And I've had the privilege of dialoguing with Anthony over years and benefiting in particular from his incredible litigation experience. So I'm going to stop there, and I believe, Jerry, you are first in the brochure to deliver your remarks, and then we'll have your interlocutor, and then Elizabeth, and so forth. Thank you.
Well, I may have to start slow. I'm trying to detach my mind from all those frigid winters in Ithaca. I not only had the misfortune of being in Ithaca for law school winters, but also 4 years of college. But I thawed out within a few years of graduation. Well, thanks, as others have said, to all of those who present and absent who funded and organized the conference. But I want to say a special word of thanks to Helen, especially, for her leadership over the years on religious liberty, but also on so many other issues that stand at the intersection of law, morality, and culture. I know it's all inside work, Helen, and calls for no heavy lifting, but doing what Helen has done requires perseverance, a lot of talent, and much, much more than the usual ration of moral courage. I'm especially grateful to Helen that she chose Anthony Piccarello as my commentator. Now, he's smart, learned, and experienced, but that's not why I'm glad. I'm glad, actually, because Anthony and I share a very special bond. We are both Brooklyn boys, born and bred. Now, mind you, our Brooklyn was not the crunchy, artisanal, pot-smoking, hipster habitat it is today. Our Brooklyn was rather a loose confederation of working-class ethnic neighborhoods, mapped out in our Catholic memories more by parish boundaries than by street names. Actually, there was a lot of pot smoking back then, too. Now, I have at hand, at least in my backpack over by Garrett and Frank, a 14,000-word paper. Helen gave me 20 minutes. Now, that arithmetic is daunting. And frankly, most scholars would complain that Helen is making them leave so many great ideas on the cutting room floor. Now, I'm modest enough to welcome the 20-minute limit. It gives me enough time to tell you what I try to do in the paper, but not enough time to actually try to do it. And I think it's easier to get an A for effort than for achievement. So what do I try to do in the paper? Well, the answer is simple and straightforward. Bury the lemon test once and for all. Now, who's heard of the lemon test, right? The three-part test. Doesn't work very well. It's a real stinker, but that's not why it's called lemon, right? That was the name of one of the parties back in 1971, Lemon versus Kurtzman. I argue in this paper that the Supreme Court should at the earliest moment straight away repudiate it. And I argue for that, and based on two distinct, I think, though complementary reasons. In fact, I think that either of the two reasons, standing alone, is sufficient to do the job. So it seems to me then, even if I'm only half right, I'm entirely correct. Go figure. Okay, the first reason, or a set of considerations, tracks closely the court's most familiar strategy for overruling an entrenched precedent, which pretty much could be expressed this way. Hey, there's already a corpse underfoot here. What else are we to do but bury it? I'm actually reminded of a story. I probably got it from Hadley Arcus, whose joke book I do intend to steal someday. But I remember the story of a glum guy sitting one afternoon in a bar, nursing a scotch, and he says randomly to the guy next to him, buried my wife this morning. And the guy, could be Anthony, says, well, I'm so sorry to hear that. First guy, well, I had to, dead, you know. So this is the template for reversal. Okay, at least Martin Nussbaum got it. I mean, it's a tough crowd. Okay, so here's the template for reversal, this first reason or set of considerations. It's most recently on display in a big civil liberties case in 2018, Janus, right, versus AFSCME, American Federation of State, County, Municipal Employees, which struck down Illinois' extraction of agency fees from non-consenting public sector employees, so the Janus case. Janus overruled, as many of you know, the 1977 holding in Abood versus Detroit Board of Education. Why? Well, the Janus court cited Abood's lack of workability. The Janus court said that its, meaning Abood's, line between chargeable and non-chargeable expenditures has proved to be impossible to draw with precision. The court said in 2018 that developments since Abood, both factual and legal, have eroded the decision's underpinnings and left it an outlier among the court's First Amendment cases. Abood relied on an assumption, the court said, that experience has falsified, and more. Well, this is the roadmap to Lemon's funeral, right? In part one of my paper, I quote extensively from courts high and low, saying exactly the same things about Lemon, only more colorfully and much more caustically. Now, topping anyone's list of these Lemon lampoons has to be Justice Scalia's sci-fi put-down of the Lemon test from 1993, Lamb's Chapel, right? You tell this story at cocktail parties, right? Scalia really did write in a Supreme Court opinion, like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. Lemon stalks our Establishment Clause jurisprudence once again, frightening the little children and school attorneys. That's in 1993. One federal judge recently wrote, I'm quoting the judge, the court's Establishment Clause jurisprudence is, to use a technical legal term of art, a hot mess. Now, in between these two, there's lots more where that came from. So you might ask, well, how much difference, given that it's dead, would finally burying Lemon actually make? Well, I think, in truth, wouldn't make any difference to the sensible content of about half of Lemon. And what I mean more exactly is I don't think we would be sacrificing anything with Lemon's demise to the sensible content of both the entanglement, that is the third prong of Lemon, or to the second spur of the second prong, which is about the religioning, inhibiting effects of government action. Those norms, if you want to call them norms, are alive and well, and I think free exercise doctrine handles them really quite nicely. The modern wellspring here, especially of non-entanglement, is probably Jones versus Wolf, church property decision, as that doctrine was importantly expanded in Hosanna Tabor. The canonical historical statement is from the 19th century, Watson versus Jones. The law knows no heresy and is committed to the support of no dogma, the establishment of no sect. So this is a kind of non-intervention norm that you find in Watson and then Jones versus Wolf. And it's alive and well, and Lemon's demise wouldn't make any difference to its survival. And what I mean by importantly expanded in Hosanna Tabor is that I think Hosanna Tabor, the ministerial exception, proceeds from this Jones-Watson norm about non-interference by public authority with the doctrine, worship, and discipline of religious groups. It's usually called the church or autonomy norm. The Hosanna Tabor court judged rightly, in my opinion, that this non-interference norm is so overridingly important that the court was justified, again, rightly, in my opinion, in erecting a wide protective perimeter around that crucial non-interference norm. This protective move depended upon just one further premise, another correct judgment, which is simply put is that personnel is policy. So I think the ministerial exception is well-grounded. It's really a matter of putting the central norm of free exercise, this non-interference norm with doctrine, discipline, and worship, to put it effectively into practice. Now, Lemon's demise is nonetheless significant. Indeed, it's meaningful, but only insofar as it means abandonment of the court's secular, of the Lemon test's secular legislative purpose prong and the top half of the second test, which is the government action must not have the primary effect of advancing religion norm. In other words, Lemon's demise heralds an epochal shift in our constitutional law because it would signal that the court's secularism project is exhausted, spent, and officially abandoned. Lemon has not formed the basis of a court, and I'm talking about the Supreme Court holding since 2005. That's the McCreary Ten Commandments case. Its secularizing norms, the first one and the top half of the second one, have long since ceased to animate a majority of the Supreme Court. Many of its rulings during the last 2 decades are flatly inconsistent with Lemon's secularizing norms. Even perfunctory affirmations of those secularizing norms, as you find them, just for example, in Justice Alito's opinion in Bladensburg, and they are there, he perfunctorily affirms them, they're infrequent, and as I say, they're perfunctory. This does not mean that it's judgment day for Lemon. I don't know what would. Now, you might be thinking that the next step in my story would be to bring the always simmering debate about the original public meaning of the Establishment Clause to one more boil. I mean, after all, if not Lemon, what? In fact, the next move is quite different and in its way far less contentious. The question presented by the demise of Lemon, again, the abandonment of the secularizing campaign, is whether the court would and should enforce the Establishment Clause, nothing more and nothing less. The justices have always and without exception stated that the clause itself prohibits a certain government preference for one religion over others. Again, every justice since 1947 would agree with the court's pronouncement, and here I'll just quote from Larson versus Valente from 83. This is the court in 83. The clearest command of the Establishment Clause is that one religious denomination cannot be officially preferred over another. Note, Lemon does not carry this command into practice. Nothing in that infamous 3-part test is needed to clarify or to justify this command. This important equality norm is not going to go down with the Lemon ship. So I think the next step has been hiding in plain sight all along. It is for the court to enforce the Establishment Clause's clear command. So we don't have a Fulton problem, or at least the problem that vexed Justices Barrett and Kavanaugh and Fulton, right? Fulton, where there's the big debate about whether Smith should be overruled, and Sam Alito wrote the 77-page historical essay, quite a spirited defense. or argument for overruling Smith. We don't have that problem. Maybe Justices Barrett and Kavanaugh are right to worry about what's next, but we don't have that problem. We know what's next, the clear command of the Establishment Clause. We don't have a Heller problem, right? The 2008, seminal Second Amendment case, where you have a set piece, toe-to-toe fight to the death between Scalia and Stevens, each issuing these historically grounded manifestos. It means a collective right to bear arms, but in connection with the militia. No, it doesn't. It has to do with an individual, probably natural right to defend oneself at home or even abroad. We don't have that problem. And so I report that as a tender mercy, I wouldn't subject you or even my commentator to one more rendition of what did Jefferson and Madison really mean when they, as the story is often told, wrote the First Amendment. As I say, the clear command of the court, or should I say the clear statements of the court as to what the Establishment Clause actually means. So my last part of my paper is really the second of the two reasons that I think each is sufficient to get rid of Lemon, and it's this story. It's that the justices have maintained openly and repeatedly, as well as in public and in private, since 1947, that their task, the one they've chosen for themselves, is to go significantly beyond the Establishment Clause, significantly beyond the Constitution, all the way to implementing their own vision of the proper place of religion in our democracy. So this is the second reason for ditching Lemon. It's really Dobbs, right? Or as Dobbs is more likely than not to go, right? Assuming Dobbs for the moment abandons, overrules Roe and Casey. The substance of the opinion will be no right to abortion is secured by this Constitution. To the extent Roe and Casey say otherwise, they are hereby overruled. And when the court talks about why that is the case, they might say, John Hart Ely's, great essay in the Yale Law Journal from 1974, to the effect Ely, who himself was, I myself have heard him say this in physically present in front of me, that politically I'm pro-choice, said Ely. But Ely said that Roe gave no evidence of desire. It's no evidence that it is constitutional law and no evidence that the court was trying to do constitutional law. The court would say that it really was, as Byron Wright said on January 22nd, 1973, Roe's an exercise of raw judicial power. It's a usurpation. It's radically extra-constitutional and therefore should be abandoned. So that's the second kind of reason. Now, the Lemon secularizing norms were minted in Everson in 1947. They are little changed since then. They come not from the Establishment Clause, its text, history of its adoption, or its judicial interpretation before 1947, but from the court's resolve to act on the basis of its own answers to much larger questions. Just for example, at the Justices' Conference 3 days after Everson, the oral argument, Justice Burton said that he would sustain the state expenditures in that case, which, to make it simple, aided religion. Burton would have upheld that expenditure to aid religion because, he said, the program is not an established church. The Constitution has not prohibited this step here. He went on to vote against the appropriation anyway. At the same meeting after oral argument, Chief Justice Vinson plainly asked Felix Frankfurter whether he thought the New Jersey bus rides establishes religion. Frankfurter replied, it did not. He quickly added, though, that the principle was much broader than simply prohibiting the model of colonial establishments. Now, these frank admissions off microphone are audible in the published opinions in Everson. Justice Rutledge's Everson dissent, joined by Frankfurter, Jackson, Robert Jackson, and Burton, stated, the object of the clause was broader than separating church and state in the narrow sense. What's the narrow sense referred to in the constitutional text? Rutledge says, the amendment's purpose was to not strike merely at the official establishment of a single sect, creed, or religion. The Everson majority's account of the clause's meaning ranges well beyond anything called an establishment at the founding. And that's just a start. Justice Black, volume 330, US 15 and 16, said that the Establishment Clause means at least this, and rattled off a whole set of norms that amounted to a secularist initiative. And he said that comes not from the clause, but from what he called the principle or the wall of separation. The next year, Frankfurter wrote in the McCollum case, which confirmed the separationist or secularist reading of the Establishment Clause from Everson. Frankfurter says, we are all agreed that the First and 14th Amendments have a secular reach far more penetrating in the conduct of government than merely to forbid an established church. Okay, note well the adverb, merely. I'm saying that once you get rid of Lemon, we can get back to merely interpreting the Constitution. So in part 2 of my paper, or one of the parts, I forget which, I multiply illustrations like these showing that the passages that I've just read really are characteristic of the justice's understanding of the relationship among the Establishment Clause, the court's doctrines, and a much wider vision about how secularism and democracy need and must have each other. Now, I would say in conclusion that the court's secularizing project is a classic example of substantive due process. But I never know whether a particular audience will judge that to be a criticism or a cause for celebration. So let's just say this. The secularism project was a judicial frolic and detour which has finally come to the end of its joyride.
Thank you for that. Jerry, that was great. I thank you for the paper. I thank Helen for the invitation. I feel like, as the saying goes, everything's been said, but not everything's been said by everybody when it comes to the thanks. So let me pile on my thanks to the rest. I also have to begin with a little disclaimer that these views are my own and not necessarily those of my employer. I gave a talk at a law school recently where I began by saying, these views are not my own. And that did not sit well. Again, I'm grateful for Professor Bradley's paper because it does set out so well not only the legion flaws of Lemon, but the trajectory of its rise and fall, kind of where it came from and where it is heading, especially in light of the various opinions in the Bladensburg Cross case, as well as kind of the similar life cycle, you might say, of the secularizing enterprise that, again, I think is properly marked to Everson and a little bit before. Again, the Jehovah's Witness cases, that was a very interesting segment, I think, about how things kind of pivoted at that moment. And then its proliferation across pretty much everywhere church and state interact. And then again, it seems to be perhaps coming in for a landing after being applied now for so long. And I share the enterprise and would join the call to kind of bring an end to that broader secularization project, or at least, again, just at least make explicit that it's already come to its end. I wanted to emphasize that point especially because I do think that resonates well with the theme of this event, which is how to protect or understand religious liberty in a way that gets out of a defensive crouch, because it does seem to me that a way to go on offense, so to speak, is to roll back this systemic hostility to religion that suffuses at least some Establishment Clause jurisprudence. So I do want to develop that in the bulk of my comments, but I do want to offer maybe a couple of caveats. I think actually Professor Bradley's anticipated them already to some extent about, say, some of the methods by which one might pursue that goal, perhaps some of the limits in pursuing it. So the first main point I wanted to make was that it seems to me that when you look at Lemon, when you look at Everson, particularly the segment of Emerson that you excerpted, the sort of famous passage, the main culprit is its prohibition on laws that, quote, aid all religions, right? In other words, if the core problem is denominational preference, then there's nothing particularly secularizing about opposing denominational preference, but there is something awfully secularizing about a principle that any government aid to anything religious is forbidden, especially when it's put in the context of an effects test later in Lemon. The net result is essentially if religion wins, religion loses, or more precisely, if religion wins in the political branches, then it loses in the judicial branch. So it seems to me that those even just few words, and it's often repeated, just in different formulations. It says, thou shalt not engage in denominational preference, but also any preference for religion over non-religion or irreligion. It's formulated many different ways and many times. That seems to me to be the core culprit. And it doesn't, if in fact the Establishment Clause can be reduced to this denominational preference principle, then it seems like you don't need any further justification for getting rid of this piece that, again, I'm identifying as the real culprit. But I actually think there is a further justification for getting rid of it. It's not just because it falls outside the limited realm of denominational preference ban. I think it's because, and again, this gets back to getting out of the defensive crouch. Government should be permitted to facilitate, query at what point it becomes advancing and what advancing means, but at least to facilitate the voluntary religious activities of its people precisely because that advances the common good, precisely because that advances the common good. Not in every particular case, of course, but as a class, on the whole, in the aggregate, religious exercise advances the common good. I think Professor Clark is going to be speaking to this in extraordinary detail, and so I'm not going to treat the subject because she's done a fabulous job of it. But for now, I think it would suffice just to say that rehabilitating the idea that religion in general affirmatively contributes to the common good is important for getting out of the defensive crouch, and that it needs to be done carefully because there are some obvious evils that are done in the name of religion. It just seems like there are some immediate counter-arguments that come quick to mind that should be taken care to address. I think they're addressable, but it's got to be done. I guess the other kind of broad caveat is that, again, I've expressed support for this idea of ending this ban on aid to all religions, but I kind of would walk it back a little bit, and maybe this is just because I've been a little too Everson brainwashed. I'm all on board for getting rid of this ban as it relates to aid to religion, quote unquote, that entails deregulation, right? So, I think Professor Laycock has said something along the lines of, it doesn't establish religion to leave it alone. Amen. I think decisions like Estate of Caldor against Thornton, Texas Monthly against Bullock, or wrongly decided. I think Amos was right in saying that you don't need to bundle together benefits to secular institutions in order for that to be constitutionally sound. Cases like Cutter against Wilkinson, yes, unanimous decision, but written by committee, very tight, very narrow. In my humble opinion, didn't need to be quite so tight and narrow. Should have been a thumping win. But then if you think about aid to religion that is broader, entailing more, say, affirmative government action rather than government leaving religion alone, I just get a little more nervous. And I haven't thought this all the way through, but my initial impression is if, I just thought of the hypothetical new proposed act, say, of the Aid to All Religions Act. Congress having recognized that religion in the aggregate does indeed serve the common good. Well, let's go ahead and pass a bill that just gives out all kinds of goodies, affirmative goodies, dollar goodies, not just deregulatory goodies, and does it, as it were, without discrimination based on sect. Ooh, big difference. Although that's everything these days, right? No, I'm sorry. So in any event, it seems to me that just gave me pause. And again, I think it's just at least because of habits of mine, but I think that just warrants some more careful examination before sort of committing to the idea that, well, of course that would be fine. Maybe. I'm also, and again, I think Professor Bradley kind of got out ahead of this, but I'm not sure. I mean, maybe I kind of see things kind of cutting two different ways in the article. Maybe you can clarify on this. Again, if the core problem or if the core proposition for which the Establishment Clause should be preserved is denominational preference, it sounds like the idea is, well, you get rid of the rest. And again, I think he's anticipated that that's not quite the argument because, again, there are other principles there that are at stake that have an independent life of their own, you might say, separate and apart from the Lemon Test. And I guess that was one of the things that I wanted to emphasize was that some of those are quite important principles. You mentioned entanglement, right? Which is, in its heyday, one of those true hot messes, right? All the, three-part test to get this, little sub-Roman 3, you consider the nature of the recipient and the nature of the A, and it just became a Rorschach test, anything that anybody wanted to superimpose on it. But there is a core principle there that's very important, again, and it relates to non-interference. I guess I am not yet convinced that excessive entanglement could be or should be taken up entirely as a matter of the free exercise clause. I think that, again, this is just an intuitive sense, but I think it's mainly because entanglement doesn't necessarily involve direct regulation. It's intrusion, it's kind of presence. It's being where you don't belong, rather than necessarily restricting or constraining or doing those things that are kind of classic free exercise problems. Related to that, and this is sort of another point where I have, I throw it on the table with some of my own reservations, but just, there's another commonly articulated principle under the Establishment Clause I think is terribly important, that has to do with sort of the idea that the church is not the state and the state is not the church, that these are distinct entities, that they have in some sense distinct roles. Doesn't mean they don't interact, doesn't mean they don't heavily overlap, doesn't mean they don't have a lot of common concerns, they can't collaborate, any of those things. But ultimately they are distinct. And you don't want the state setting up a church, you don't want the state behaving like a church. In other words, is the problem with the state setting up a church only the fact that that represents an implicit denominational preference for that church they have set up? Or is it also because that's just not the business of the state? The state is incompetent in that area. So I'm thinking about the work of like Carl Esbeck, especially talking about Establishment Clause as a jurisdictional limit, a structural limit, emphasizing elements like governmental incompetence in matters religious. I think those principles are important. There's sort of a flip side to it, which again, I have even more reservations about, but I'll lay it out there. Larkin against Grendel's Den, where the church is behaving like the state, as it were, where the church is being delegated a governmental function. Do we want to get into that line of business? I don't think so. So again, I wouldn't, I do hear that you don't want to throw out the baby with the bathwater, but I just want to make sure that all those babies are saved. So I think I probably used up my time, so I think I'll probably.
Are we keeping time back there? We're good. I think you still have like another 5 minutes, right? Approximately.
Well, maybe
if you
I'll.
want. But you can save that and we can have dialogue after
Okay.
Elizabeth and Shannon, and then we'll all talk if you'd like to raise more things then.
I will, but let me just add 30 seconds and then I'll
Take
wrap
your
it
time,
up.
take your time.
The thing that I wanted to add with closer to the mic, sorry about that. How's that? Sorry. Just a quick point on excessive entanglement, just that I think one of the ways that that's especially powerful and effective, and this is not hypothetical, this has happened, NLRB against Catholic Bishop of Chicago, is when it is paired with a constitutional avoidance concept. I mean, one of the problems that I think you rightly identified in terms of the development of the Establishment Clause jurisprudence was that there's too much prophylaxis built in, right? How about some prophylaxis on the other side? How about, again, talking about pivoting the direction of this and the momentum out of a defensive crouch? How about, yeah, it's theoretically possible that the state and the government could interact in a way that doesn't harm religious freedom. But again, adding in that element of constitutional avoidance, which adds in that element of prophylaxis, might serve well, sort of, you might say, free exercise type interests. So with that, I will shut up. Thank you.
Thanks so much. It's going to have you present next. Thank you.
I'm delighted to be here and grateful to add on my thanks to John Coop and Helen Alvarez and our speakers who've already launched us in really fascinating and thoughtful directions. Look forward to the discussion. And I'm grateful for Shannon for being my partner in crime here. My paper is a slightly different take than some of the others. I'm trying to give sort of more the 30,000-foot view of religion. Why? Why does it matter? Why does protecting religious freedom matter? If we're going to move beyond the defensive crouch, we need to have a positive vision of what religious freedom is and why religion matters. And I think as we see a decrease in religious affiliation across the United States, answers to those kinds of questions are no longer assumed. And frankly, I think that's a great thing. I think it's an opportunity to really put forward and see what religion is. Sort of buying into modernist mindsets, we often see religion as just a private preference or choice or value, or maybe even an identity if we're being really generous. But I'm going to go through empirical findings, and I think when you look at this, it suggests that even though religion is all those things, it's far more than that as well, and has an impact that's enormous. I'm going to look at that impact in terms of individuals, families, and society. I'll be using empirical research and sociological political theory on religious practice, beliefs, and membership. I also have a paper that is far too long to give in 20 minutes, so you'll be hearing the highlights. Everyone's very grateful. So I've got the details, but I'm going to give you just the quick rundown line summary of some of the findings, because I think just seeing them one after another is just impressive. But as I'm focusing on the measurable and explainable, I just want to, at the outset, remind myself and others, the sociologist Christian Smith had this wonderful comment, which is, there's something particularly religious in religion, which is not reducible to things not religious. Right, so I'm going to get back, if I have time, if I don't overdo it here, to this question of the non-extrinsic experience of religion and value of religion. But I think at the very outset, it's useful, even though it's not complete, to have a reminder of what is describable in religion and the impact it has. Now, saying this, I'm also not unaware of the fact that religion can be used to harm, and that there's differing assessments of the value of particular religious norms. And I'll get to that a little bit too. But I think that some of those concerns have led to a wholesale dismissal of the value of religion, which simply isn't warranted. I'm not arguing that religious activity should be protected in all cases. There's lots of interesting religious freedom issues that I'm just not going to get into. But I am making the case that there are important public reasons why religion and religious freedom deserve protection. So looking at individual, family, and society. At an individual level, active religious attendance and faith community harmony have been found to contribute to greater well-being and life satisfaction. In fact, this is so well established among sociologists that instead of like many lawyers saying, well, why does religion matter? The main thrust isn't whether religion contributes to well-being and life satisfaction, but what aspects of religion contribute to well-being and life satisfaction. In many cases, religion is also correlated with physical and mental health, not with exercise though. Religiosity has been found to shelter individuals from the negative effects of living in underprivileged areas and is associated with reduced criminality. Religion and the work of religious institutions are linked to rehabilitation, pro-social behavior in prisons, and reduced recidivism. Religiosity in youth is positively correlated with physical and emotional health, negatively correlated with risk-taking behaviors and the use of illegal drugs. Active religious participation, in fact, there's an article in the New York Times a week or two that just sort of a sub-point on that issue. Active religious participation and religious beliefs about family ties are associated with improved marital stability, increased levels of marital satisfaction from both parties, reduction in verbal aggression by parents with children, and better self-reported parent-child relationships. There's more. How does religion produce these kinds of results in individuals and families? And this is, I'm quoting again, sociologists and those who study families. They suggest a range of reasons that religion provides what they call psychological insurance, stress buffering, to help with adverse circumstances. It provides explanations for hardships, provides communal rituals for important life events, provides a social safety net, combats excessive individualism through a sense of belongingness and a network of support. Religious norms that not only discourage antisocial behavior, but actively promote pro-social behavior. These religious norms are seen as providing clear moral guidance, encouraging good health practices, encouraging social contacts, and charitable giving, and help internalizing a sacred view of the family. Religions also create relationships that give accountability to reinforce positive behavior. Religious, sort of like AA groups. Religious communities build positive social linkages, spirituality, service, honesty, identity transformation, which in turn discourage criminality and recidivism. For youth, sociologists see that religion establishes a moral order, provides spiritual experiences, coping skills, role models, provides community and leadership skills, and other cultural and social capital. And this is where we flow into societal benefits. These benefits to individuals, it's already obvious that they contribute to the community as a whole, but I'd also like to look at some benefits that accrue directly to society. And I'll just mention 4 and go to each one just a little bit. Social capital, charitable engagement, sources of norms, and having a peace-building role. So again, sorry for the laundry list. If you want to read the whole paper, you can get more details as well. But religiously active citizens are more civically active and positive about their communities, more likely to vote, more likely to volunteer, including in non-religious causes. They're more likely to talk to their neighbors, and they're more likely to give to charity. They build social capital, including reciprocity, trust, trustworthiness that facilitate trade and community life. Robert Putnam, the father of sort of social capital thought, argues that faith community, quote, faith communities in which people worship together are arguably the single most important repository of social capital in America. And they comprise half of all personal philanthropy and volunteering. In addition, religious communities help individuals acquire the values and skills so that they can participate effectively in politics. They provide an important vehicle for intergenerational transfer of social norms, encouraging social ties and social support. The sort of second major social impact is through the charitable sector. Faith-based associations have an enormous impact charitably in the United States. They provide almost 60% of shelter beds for homeless individuals, educate over 3 million children a year, provide 20% of all hospital care, and are the majority of volunteers in restorative programs in prisons. Religious individuals adopt children at more than twice the rate of non-religious individuals. Religious individuals send 4.5 times as much money in international aid as the Gates Foundation. Religious organizations also, and another sort of way of looking at this, is providing a reservoir of social norms and deep commitment. These often include democratic values, such as tolerance, reflective thinking, generosity, altruism, law-abidingness, and reverence. That in the sense of, you think of Lincoln's second inaugural, or preventing political leaders from excessive hubris. A little bit of reverence can go a long ways. Religious beliefs also have been seen as compensating for liberalism's notions of neutrality towards the good life that you need to have a liberal system, but it still helps communities retain commitments to values, sense of community, and civic engagement that liberty needs to flourish. In essence, religious norms provide a thick component to social life and can combat the atomization of the modern liberal state and the epidemic of loneliness with its attendant health impact, which is larger than that of smoking. Finally, looking at the peace-building side of religion and its contributions to society. Religion is a source of social justice and peace. As a mediating institution, religion can check state power, provide a voice to challenge reigning norms, social norms. Studies show that religion is associated with the majority of nonviolent campaigns for political change and has played a role in over half of democratic movements in the area that was studied. Religious organizations and individuals play a role in mediating and into violent conflicts, contribute to transitional justice, and were involved in 8 out of 10 truth commissions. Think Archbishop Desmond Tutu. Religious disengagement is correlated with increased racial and ethnic intolerance and movement from the political middle. So how does religion accomplish this in the social sphere? Well, theorists argue, and sociologists, that the social benefits of religion flow from the social capital, the values, the web of trusting relationships that are created with religion and with people who are religiously active, that the training that they provide for civil and social life. Evolutionary biologist Jonathan Haidt describes it as tapping into what he calls the hive switch of how humans can cooperate and have been able to survive by being able to work together as a group effectively. Certainly religions may legitimize and preserve social order, and I'll get to that in a minute, and that can be an enormously difficult thing, but they can also challenge society and government. Sociologist Christian Smith gives 7 reasons why religions have such power in fostering charitable and social work. He mentions transcendent motivations, moral imperatives, organizational resources, shared identities, local and transnational social and geographic positioning. There's local as your local church, but also in many cases have ties that stretch across countries and across other boundaries. Have a privileged legitimacy and institutional resistance to state encroachment. They have a reason to resent the state. Religions can justify and implement social justice claims in ways that states, aspirationally in many parts of the world, put into their constitutions, but are very difficult with social and cultural rights. But religions are in a unique position to be able to have that as a norm that can be enforced through their actions. Religious rituals, mandates, and faith-based organizations who act with institutional integrity are uniquely positioned to bind this as community together and promote social justice. And social movements finally also benefited by the power of religious symbols and spiritual credibility. I've done a lot of work in Russia and Ukraine, and you see that over and over again is the power of religion as a symbol, as a motivator, as a force of connection. I could go on to that, but that's a different talk. So as we see with these values that come to individuals and families and communities, religion and religious organizations have a public value. And this has been recognized by those who aren't religious in many cases. Atheist Alain de Botton, for example, recognizes religious ability to meet what he calls central needs, which continue to this day, and which secular society has not been able to solve with any particular skill. First, he says, the need to live together in communities in harmony, despite our deeply rooted selfish and violent impulses. And second, the need to cope with terrifying degrees of pain, which arise from our vulnerability to professional failure, to troubled relationships and death of loved ones, and our decay and demise. He says, religions have all made significant contributions to mainstream politics, but their relevance to the problems of community are arguably never greater, he says, and I love this, than when they depart from the modern political script and remind us that there's also value to be had in standing in a hall with 100 acquaintances and singing a hymn together, or in ceremoniously washing a stranger's feet, or sitting at a table with neighbors and partaking of lamb stew and conversion, the kinds of rituals which, as much as the deliberations inside parliaments and law courts, are what help to fold our fractious and fragile societies together. Now, I promised to come back to the question of religion's negative aspects. This is crucial to understand as well. Religion's been described as ambivalent. It's certainly paradoxical. It teaches social norms that are seen as positive and pro-social, but these have also led to discrimination and hostility to those seen as deviating from the social norms. And this is particularly raised by many in the sphere of gender and sexual identity, orientation, and expression. Religion promotes the values needed in liberal democracies, but for thousands of years has also been used to prop up monarchies and repressive governments. In many cases, variations of the same belief can promote a liberal democratic system or oppose that system, leading to interesting discussions within the faith community. I think it's worth taking a step back and saying that this problem is not exclusive to religion. This faces anyone who's advocating some kind of a thick communitarian approach. The philosopher Talese argues that, as he says it, communitarians need to devise a way in which essentially social and unencumbered selves could adopt a self-critical stance that can weed out and correct the oppressive, intolerant, and homogenizing tendencies of community without evoking liberal notions of civil liberties and individual rights. Right? Then it'd cease to be sort of a thick communitive one if they instead relied on civil liberties and individual rights. So in other words, he says, they needed a conception of community that was at once binding and plastic, a politics that was both formative and fluid. And I think what he's getting at for terms of religion, this kind of self-critical stance that can weed out oppressive or intolerant features, brings us to the question of religious freedom. I think you can only have that kind of freedom within a religion and freedom to leave religion if you have a strong and robust protection of religious freedom. When you have a legal regime that ensures exit rights, minimizes restrictions on religious freedom, religion can tap into this unifying power and be also binding and plastic, formative and fluid. And studies uphold this too, and I could go on, and I'm sure I'm going to go far more time, so I will keep this very short, but there's more to be said, that studies show that religion is most likely to be associated with war, terrorism, lack of democracy, repression of other beliefs in countries that themselves are religiously unfree. Governments are often the ones who abuse religion, and certainly I've seen that in Russia and Ukraine right now. Religions that are free and endorse religious freedom are also more likely to serve as mediators in conflict situations. They're also more likely to have countries with lower degrees of religious hostilities and higher degrees of individual well-being. And religious freedom is often bundled with other civil rights, you'll see, and political stability and economic goods. I think interestingly, even sort of LGBTQ rights and gender empowerment, where religions often faces tough criticism at the moment, or at least some versions of religion, but where there's religious freedom, the average level of support for LGBTQ rights is actually 38% higher in countries with high levels of religious freedom. And frankly, it makes sense. For many, religion is one of multiple overlapping identities that the cultural wars sometimes tend to forget. Religious freedom allows for choice and voice on religious matters. And I think religious freedom is also crucial for the institutions themselves. As we were talking here earlier today, I was thinking of a time when I was in Uzbekistan and I met the government minister for civil society. I asked him about his job. He said, "Oh, my job is to create civil society." You know, some things just don't work quite so well if they're not free. And I would say religion is one of those things. So, and finally, in conclusion, let me just say that religion has tremendous impact for good, but simply can't be reduced to its non-religious aspects and benefits, much and considerable as though they are. Most believers won't talk about cross-cutting norms and social capital. They'll talk about meaning and purpose. And those are very difficult for sociologists and others to quantify, but are really crucial to an individual self-understanding. And I think trying to rip the two apart is impossible, because the other regardingness of religion loses its power without religion's reification of a divine other or identification of a transcendent reality. I love the description that German philosopher Hans Joas has for the experience of religion. He spoke at a historical meeting of German Protestant and Catholic clergy in 2003. And he argued that our need for religion cannot just be understood by looking at the external value or usefulness of religion, but more fundamentally at the need for the experience of belief. He said, the question is not, is religion useful, but can we live without the experience articulated in faith in religion? He goes on to describe this in terms of self-transcendent experiences, where we get pulled beyond ourselves, being captivated by something outside of ourselves, or relaxation of liberation from being fixed on ourselves. And he describes that these kinds of self-transcendent experiences come often in response to beauty or the horrors of nature or other folks, love, loss, brotherhood, vulnerability. These come to everyone, but religious traditions, in his view, are particularly powerful because they articulate these self-transcendent experiences. They help provide a rich repertoire of interpretations. How do I make sense of this? I think of Dostoevsky and writing about sort of fate and free will and the meaning of life. It's powerful repertoire drawing on religious traditions, facilitating, and religious institutions facilitate having such self-transcendent experiences in the first place, teach us things that put us in a place where we can experience that. And then he ties these also to the commitment to religious freedom, that when we've experienced this, then we want to help others to have the opportunity to develop their own authentic and unforced relationship to God. So to summarize, to finally wrap up, my purpose is not to say, let me be clear, that religion is the only source of good. I'm not going to make that claim. I'm also not going to make the claim that religion is always a source of good. But I think the evidence is really overwhelming that religion is associated with significant individual, family, societal goods. This is not merely a private preference, choice, or value, but has significant repercussions in society as well as for individuals and families. And that these benefits are enabled and negative aspects of religion are minimized when religious freedom for all is robustly protected. Thank you.
Shannon, thank you.
Yeah. Okay. It is such an honor to be here, and it's just a great pleasure to have the opportunity to respond to this magnificent paper. You all must read this paper. It is really a tour de force that just pulls together an enormous amount of research and different strands of thought and casts the justification for religious liberty into a very important new light. And I've conveyed this privately to Professor Clark. I feel badly that your paper doesn't have a more kind of worthy respondent, but I will just say selfishly, I am delighted to have a chance to highlight some of the insights from Professor Clark's paper and suggest some of the ways that it sheds new light, in particular on LGBT issues and rights, which is the focus of my work. But really, Professor Clark just does a magnificent job with just unbelievable, like just encyclopedic breadth of rebutting some of the most pernicious stereotypes and misconceptions about the role of religion in our shared world. You know, I think particularly the misconceptions that religion fuels intolerance, violence, repression, that it results in harmful family formations, that it leads to the mistreatment of women and LGBT people, that it tends to inhibit individual freedom of thought and open-mindedness. And I realize that these misconceptions may have less purchase in this audience, but they certainly have very widespread valence in the broader world, and particularly among progressives. You know, unless, you know, you're living under a rock, you know, we've all seen, and I would guess, you know, experienced the culturally and politically toxic kind of impact of this very widespread belief now that there is a culture war, that there's a civil war, that pits conservative religious people just implacably and forevermore against the LGBT community. And there seemed to be a never-ending stream of cases that pit these two groups against one another and that are constantly kind of threatening or promising, depending on your perspective, to give the Supreme Court an opportunity to sort of rewrite the fundamental framework established by Justice Scalia in Employment Division versus Smith. And the Supreme Court has already, in very recent history, kind of twice taken up cases that might have led to such a revision. You know, first in the Masterpiece Cake Shop case, and then again more recently in Fulton, and then in both cases they stopped short of doing so. And now the court has once again taken up yet another case that presents it with that opportunity again, although this time it would be under the rubric of free speech rather than freedom of religion. But anyway, my point in mentioning these cases is not to kind of retread this already extremely well-trodden ground, but just to note how largely this allegedly intractable conflict between religious freedom and LGBT rights just looms in our political and legal world. I'll just say that Professor Clark's paper is just such a refreshing antidote to that myopic fixation on that, purported clash. Really, I mean, reading her paper was just exhilarating. I felt like I was just watching this grand landscape kind of emerge from darkness and shadows, and it's like looking at a map with a little pinpoint of light on that conflict that just illuminates a fraction of a much larger territory, and then it just kind of experienced this floodlight revelation of how that little piece fits into just a much larger picture. I think it was really inspiring, honestly. Like, I think properly understood, as Professor Clark's paper helps us to do, it really could not be clearer that the causes of religious freedom and freedom for LGBT people have much in common, are much more synergistically related than they are opposed. And the very fact that that might seem to be a shocking or implausible statement is just a testament to how much we need the type of expansive analysis that Professor Clark is providing. And I just want to note that I think it's no coincidence that she's able to bring that breadth of perspective to our domestic political landscape, in part because of her deep expertise on the international landscape and the role of freedom of religion, or the lack thereof, in countries such as Russia and Ukraine and other parts of the former Soviet Union. And if there ever was a time when advocates of religious freedom and freedom for LGBT people should seriously be pondering our common goals of preserving liberal democracy, I mean, surely it's now, when we see so many democracies across the world faltering, or as Professor Clark puts it in her paper, I love this metaphor, kind of gliding towards authoritarianism. In this country, really for the first time in recent memory, in my adult life, there is a serious questioning of the basic premises of liberalism, of liberal democracy, from both the right and the left. And I realize there may very well be some folks here today who are drawn towards some of those recent critiques of liberal democracy from legal and political scholars such as Adrian Vermeule or Patrick Deneen. So I'll come back to that in a minute, but I just want to note Professor Clark's thesis that religion, religious faith, participation in religious communities benefits individuals, families, society as a whole. With respect to society as a whole, it does that by creating social capital, by supporting charitable and social justice projects, by reinforcing social norms that support liberal democracy and promote peace. It is a paradox, really. It's a paradox that there is overwhelming evidence that religion is not only one of the pillars of social stability and individual and family flourishing, but truly it is the single most important source of those benefits. And the paradox here is how can it be that people who have the conviction that this world is not our home, how can that lead to such a deep investment in the world and to so many pro-social benefits? But it does, it indisputably does. People of faith in so many ways truly are the salt of the earth. We can imagine, in some faiths invite us to do this, what would happen if people of faith suddenly were to disappear from the world? It would be a grim and frightening place. I mean, it really would be, kind of Mordor. And this is, which is something I always think of whenever I travel to DC. This is not to downplay the harms that religion can cause and has caused, and Professor Clark deals with that very thoroughly in her paper, and that does, as she points out, those harms tend to arise when religious freedom is curtailed, and especially when the state kind of co-opts a particular religious faith. But with that kind of, that broad summary in place, I want to focus on two of Professor Clark's points in particular and how they apply to LGBT people and advocacy. And the first is just the enormous benefit of religion to young people, which include, as she points out, adolescent physical and emotional health, educational accomplishments, social and community involvement, and family well-being. And just frequent church attendance is one of the most protective factors from a variety of harms, especially including like drug and alcohol abuse. I've spoken about this many times before, but it really bears repeating. That one of the great tragedies of our society is the reality that many LGBTQ kids are just brutally and cruelly excluded from those benefits at just enormous cost to themselves, their families, our society as a whole. I mean, there is a reason that LGBT youth experience suicidality, depression, anxiety, substance abuse, dropping out of school, many other grievous harms at much higher rates than other young people do. There's a reason that upwards of 40%, like almost half of homeless youth, identify as LGBT. There's a reason that about 20%, in some places higher than that, 1 out of 5 of every young people who are in state care, in the foster care system, or in juvenile detention identify as LGBT. I mean, we've really lost the collective ability to be appropriately shocked or horrified by those statistics, but I just want to say, this is not normal. I mean, this is not only a public health crisis, but it really is just a searing indictment of our failure as a society to support and nurture and care for a significant segment of our own children. There's few situations that are more likely to result in crushing harm to a young person than to grow up in a religious family, a religious community, then to discover that one is gay or transgender, and then to realize, just confront the complete absence of any constructive or positive path forward. There's no story, there's no life narrative, there's no script that's available to that young person within the parameters of their faith. And then parents of those children experience the same just crushing lack of any way to understand, how can my child have a happier, productive life as a LGBT person, which then often leads out of love to desperate attempts to protect their children by trying to discourage them or prevent them from being gay or transgender. That is then experienced by the child as rejection and has disastrous consequences for that young person's health and well-being. The harms that come from that dynamic are serious. There's a lot of research, children who are subjected to parental efforts to change their sexual orientation or gender identity, 8 times more likely to attempt suicide, and more than 2/3 of kids who are subjected to those efforts, both by parents and then by an outside person, whether it's a therapist or a faith leader, 2/3 of them attempt suicide, not just suicidal ideation, but actually attempt suicide. So I want to be really clear here about what I'm saying and what I'm not saying. I am saying that religiously based family rejection is devastating to LGBT children, that the results of it are enormously harmful to our social fabric, our stability, our well-being as a society. I am not saying that the only remedy for that harm is for conservative religious faiths to change their doctrines about human sexuality, but rather, notwithstanding those doctrines, that these families and communities can find ways that are rooted in their own traditions and cultures of understanding and supporting their own children, of avoiding the crushing harms that result from those rejecting behaviors. I mean, it's interesting, and it's really important, I think, that there's a lot of research that the most severe harms that are caused by family rejection can be almost entirely mitigated just by moving families from rejection to ambivalence even. You don't have to be celebrating these identities. And families certainly can embrace and love their LGBT children and provide them with the adult support that all children require, no matter what their doctrinal beliefs are. I mean, just as one presumably would do if a child embraces a different religious faith or a different political view from their parents. But the problem is not so much, that with doctrines that hold out heterosexual relationships as the ideal or even the only acceptable option, it's more the weaponization of those doctrines to reject LGBT people in a very unique way, to kind of single out being gay or transgender as just uniquely reprehensible or sinful. And I think one of the most positive and encouraging developments in this last decade or so has been really the just astonishing emergence from within a whole bunch of different conservative faith traditions of new understandings, new initiatives to sort of rectify, come to terms with and rectify the historically unduly harsh treatment of LGBT people. And I'll just share a really quick personal story, but when I came out as LGBT in high school in a conservative religious family in Texas, my parents, who of course, love me dearly, they really fell prey to this dynamic and engaged in just precisely the sort of shaming and isolation that, we now know to be so damaging to young people. And they did it to try to help me, not to try to hurt me, but I don't think I would have survived that experience if it had not been for the intervention of my high school government teacher, Mr. Jackson, who was this just deeply conservative Christian evangelical. but he was the only adult in my world who reached out to me to offer support. And he told me, unequivocally that according to his religious beliefs, being gay was a sin, but he said it's no more sinful than many things he had done. And I felt his unconditional love and support very clearly, and it was enough to keep me alive. And as you can probably tell, I still think of him with, with a great deal of gratitude to this day. And I'm sharing that story just to emphasize how sincerely I mean it when I say that finding a way to embrace and support LGBT youth is not necessarily about changing doctrines so much as about changing behavior. And there's a lot of recent examples of this from different faith traditions. I mean, the current Pope, for example, has really stressed the importance of embracing LGBT people, but he hasn't changed any of the doctrines about human sexuality. And I do want to say that some of the blame for the failure, and I could go on about this for a long time, some of the blame for the failure of many conservative religions to develop their own sort of organic ways of including and embracing LGBT children, I think it does lie to some extent with the LGBT movement, which is just far too often, casts religion as the enemy, and even sometimes appears to cast families as the enemy by just assuming that conservative families are going to reject their kids and that the only solution is for LGBT children to try to hang on till they're 18 when they can leave home and move to a gay-friendly city somewhere. And this, just tragically misguided. Just really quick, there's a story someone shared one time of working on a book about LGBT youth and talking to a 16-year-old in North Carolina who was experiencing harassment at school and rejection by his family. And she found herself saying to them, well, just hang on, when you turn 18, you can move to a city. And this kid, this always chokes me out when I try to tell this story, but this kid said to her, thank you, ma'am, but I don't want to leave my family. I don't want to move to a city. And when the time comes, I want to sit in heaven with my parents and grandparents. And, the LGBT movement just hasn't had a lot to say to kids like that. But okay, so I want to wrap up here, but I just want to close by noting that Professor Clark's observation that, notwithstanding our myopic focus on the potential conflict between religious freedom and anti-discrimination protections, in reality, religious freedom, other freedoms, often closely correlated. I noted the same statistic, Professor Clark, that you noted from your paper, that the average level of support for LGBT rights is 38% higher in countries with higher level of religious freedom. I just want to close by noting how profoundly true that is and how deeply democratic beliefs in the inherent equality and dignity of every person are ultimately rooted in religious faith. I'm reminding of the remarks of Senator Adams from Utah when he supported that state's anti-discrimination law for LGBT people, that he did so not in spite of his religious beliefs, but because of them. I think we've trained ourselves to focus on the relatively few and far between areas where there is or can be a conflict between equal treatment of LGBT people and religious liberty. Oh my gosh, we've given that conflict just a totally outsized importance that it does not merit. I mean, yes, in truth, these conflicts arise, but they arise mostly only at the margins, and they don't need to be intractable. I mean, with just the least bit of creativity or sort of mutual effort, there are solutions that can be found to those marginal problems. I mean, that is the very purpose of politics, political compromise, legislative provisions that provide for reasonable religious exemptions. But too often these days, rather than engaging in that political give and take, we've just allowed these marginal conflicts to obscure the much greater extent to which religious freedom and equal treatment of religious and sexual minorities are not only compatible, but they rest on the same principles and values and beliefs about the importance of individual freedom, autonomy, the inherent dignity and worth of every person. I mean, just to take one example that I think is really heartbreaking, I just think it's tragic that when we think of religious social service agencies in connection with LGBT people, the first thing that's liable to come to mind is the conflict between some religious adoption agencies and anti-discrimination protections for LGBT parents. And that was, of course, the conflict in the Fulton case. But that's real, but it's important to remember that with respect to almost every single other thing that religious social service agencies do, there's no desire to discriminate or practice of discriminating against LGBTQ people, To the contrary, most of those religious social service agencies will gladly provide their services to homeless people, people who need to eat, whatever the service may be, refugees, to everyone who needs them, regardless of race, religion, sexual orientation, or gender identity. So Professor Clark ended her paper with this really powerful and elegant insight that she said, simply put, religion matters to individuals, families, and communities. And because it does, religious freedom matters as well. So I'm just going to offer a parallel closing thought that, simply put, democratic pluralism matters to both LGBT people and people of faith. And because it does, our relationship and our common commitment to preserving the institutions, the norms, the social and political culture that supports democratic pluralism matters as well. Stop there.
Thank you so much. We're just a few minutes early, so I was going to start off some Q&A here with a question for each area that we dealt with. On the lemon question, there is a very strong gut response when formerly Justice O'Connor, now you've got Justice Kagan, Sotomayor, referring to one of the goods that non-establishment is supposed to preserve as equal citizenship, right? Making everybody feel that they are an equal citizen, not disadvantaged by their government. And I'm wondering about getting rid of that part of Everson that talks about religion versus non-religion in relationship to that, And then on Elizabeth and Shannon's piece, the question of why the government might not say at some point, well, thanks for all the good stuff, but we can get a lot of that from you without much religious freedom. And that y'all have been so great on the social services for so long that, we know, and it's an intrinsic part of your belief. We don't really need as broad a religious freedom as you want. So anyway, those were just questions that occurred to me. I want to turn it over first to Jerry and Anthony to start, and then we'll take your questions.
Well, what I'd like to do is probably not going to be permitted by Helen, which is to refer the question to Steve Smith over here, who published 30 years ago what remains the best article on the no endorsement test, which is basically what Helen's referring to. And I think it has, as you suggest, been picked up by Kagan. I'm not sure about Sotomayor only because my own memory is faltering, but I think Kagan has, if not embraced the endorsement test, she certainly has a strong attraction to it. I think it's unsound for reasons that I'll just state in about one or two sentences, but I think I should say, before I do that I think its soundness or unsoundness can swing free of the Lemon test itself. And what's attractive or appealing about it, is powered by a norm of equality, but a kind of equality of feeling belonging, something like that, which I don't think is tied in a particular way to Lemon or even just no sect preference. But I think what's wrong with it is fundamentally this. I think it depends finally on a presupposition about the relationship of religion to the common good. So that really, if religion and other people's religious liberty and everybody's religious activity were conceived as a common good, and even by persons who themselves are not religious, which not religious persons can and I think should recognize that religion is part of the common good, then I think analytically at least, the appeal of the idea of no endorsement, we shouldn't have outsiders and insiders, first and second class, I think all of that just begins to evaporate. That it depends upon its appeal analytically at least, not emotionally perhaps, but its appeal analytically depends upon, I think, supposing religion is private. And that when it intrudes in a public space, it's someone else's thing or stuff that has gained a kind of upper hand in our public life, whether it's a legislative prayer, the Bladensburg Cross, or you name it, the Ten Commandments, I suppose. And that's the source of, I think, the analytical force, such as it is, of the no endorsement test, that it's really not about our common good in religion, which has a particular manifestation on a particular occasion, but rather when that manifestation is in view, someone else has got the whip hand, and it's not me, and that ain't right, because we're all equal here.
Just one quick point to add to that. Just the role of standing doctrine in this discussion. I mean, I don't want to be dismissive and say what's the harm, but I just wonder if that harm, though subjectively real, is justiciable and is properly within the sphere of concern of the Establishment Clause, properly understood. So it seems to me that's one way to sort out situations potentially where you're dealing with, in fact, the denial of equal citizenship. I wouldn't want anyone to be denied equal citizenship. But does that denial consist in, a subjective experience of exclusion where perhaps there is not actual exclusion? It's just a sense of discomfort or alienation.
And I'm thinking about those times when the court will even qualify this on the endorsement side and say, well, it's what a person who knows about what the program that the government is doing, and they take a reasonable position on it. No, they're not endorsing this. Within the context of this program, don't they see there's all these other people benefiting, so their ox is not being gored? It does get to be a complicated test in the end. I'll stop now, Elizabeth.
Well, thanks for your question. And it certainly does happen where governments want to take advantage of churches. So this is a religious freedom problem worldwide. And particularly what tends to get trampled are minority rights and institutional rights, usually of the largest churches, actually. And I think my would be there's strong reasons why the government shouldn't do that. Yes, is it going to happen? Yes, it does. It happens all over the world. But those two areas in particular, the beliefs of minorities and institutional rights, are key parts of what makes religion able to contribute to society. The minority beliefs, for example, there's a really interesting study that was done in New York State looking at refugees. And across the board, even if they weren't personally religious, the thing that made them most comfortable in their society and feel safest was if religious freedom was being protected, even if they themselves weren't very religious. So part of it is having individuals able to feel a part of their community and contribute means showing them some recognition. For institutional rights in particular, I think there's a lot of data tracking that governments that have increased restrictions on government on religious freedom also face greater social hostility. So it's a lot of you may get some of the goods, you may get some people running a soup kitchen, but you're going to lose some of the bigger goods.
That's the connection I was hoping. Shannon?
Oh, yeah, just to echo that, I think is that just to say, as you just said, that the common good that religion supplies is so critically dependent on the protection of religious minorities. And so I do think there's a little bit more of a tension there. There's a thin line between recognizing religion as a common good and allowing majoritarian preferences to kind of overtake us. So, yeah.
Let me turn it over to you all. There are microphones on either side, and we would love to hear your questions. At least they would. And, and I will no longer be speaking. Professor Argus?
Okay, I'll take a try. We had the Town of Greece case several years ago, and that set off a new growth industry. We have invocations before legislative councils. And that set off a new growth industry for Satanists and ministers of the Church of the Flying Spaghetti Monster. Because our people have fallen back on the notion that we'll simply respect as religion anything that claims itself to be religion. And the court has drifted into that, but we can't make any these kinds of invidious discriminations. So we back ourselves into the notion that, as Jerry said, we not favor any religious view over another's. Look, the God of the Declaration of Independence, the author of the laws of nature, was also the author of the moral laws. I don't think the God of the Declaration could be reconciled with Satanism, right? And if you had a notion of a religion taking at its core the teaching of radical evil, well, I don't think that kind of teaching would have quite the positive effects that Ms. Clark is thinking, or that it would actually serve the common good. So I think what you're touching here is something that we want to protect religion, yet the problem is our people have had a hard time settling on what we understand to be that religion that we seek to protect. So we fall back on the equality principle, which is very good for us. You're creating a religious disability. So Joshua Locke is barred from his studies at the University of Washington, and we had a chance there to say, Scalia said that it is a distinct disability based on religion. And that seems to be one of our most critical levers now. But again, I put before you the notion that the difficulty of our people is that we are reluctant, quite reluctant to speak about any grounds on which we judge any one religious claim to be more or less legitimate than another, and that confounds our concern for casting protections throughout religion, and we're not quite clear on what it is we're trying to protect.
Well, this topic came up in my civil liberties class about a month ago. I was teaching the Coach Kennedy case, the Bremerton School District case, the coach who prays at the 50-yard line. The court's granted cert. It was part of the free speech part of the class. And there's a couple of lines, at least, in the Ninth Circuit opinion about the Satanists. And the Satanists, or the local chapter of Satan's, United, or something like that, I sent a letter to the school district saying pretty much in these words, if you let the coach keep praying on the 50-yard line, we're going to demand equal time. So I took it up with my students, and my students insist that Satanists aren't what Hadley and I think they are. The students insist they're kind of misunderstood free thinkers who kind of like getting in the face of conservative Christians, but I'll put that aside. I don't know. I have to say, none of my best friends is a Satanist. But as Hadley suggests, I mean, taking it is a serious question. I think I'm inclined to agree with Hadley. Now, it came up, we'll see what the court does anything at all in the Coach Kennedy case with this little Satanist diversion. But it came up in the oral argument in Grease and Galloway. I don't remember if it was in the Supreme Court opinion. I don't remember. But it came up in the oral argument of Grease and Galloway, the legislative prayer case from 2014. And Scalia and maybe one or two other justices, they were playing around with it. Like, well, they have to have, they have a wicker person saying a prayer, and what about this one? And Scalia's playing around with, well, what about the devil worshipers? And it's funny, you look in a transcript, and Scalia drops that like a kind of punchline. And actually the transcript says laughter, so. But I think that the one way to get at it, and I try to get at it with my own students, is say, well, let's leave aside whether they're just, playful free thinkers, and take it as a serious position. I said, so if Satan means anything, the devil, I think it means a kind of, whether it's personal or not, a cosmic principle of evil. Now, in legislative, we don't pray to a cosmic principle of evil, right? We don't do that. That's not what prayer is. That's not what they're trying to do in Greece, New York. And we don't pray to the devil. Okay? We don't want a principle of evil's help, guidance, benevolent attention, right, when we undertake the serious business of governing. So that's one way to get at it, is say, well, look, what is it that we're actually doing here? And does an appeal or use or resort to a cosmic principle of evil accomplish that end? And I think the answer is usually no. Now, that's different from a true public forum case when people with all sorts of cockamamie ideas stand on a kind of stipulated equal footing. That's different. I'm talking about Satanism, the real deal, in connection with freedom of religion. And I think it's a distinction that ought to be drawn and should be drawn because of the nature, purpose, and function of appeals to God or exercises of religion. That's what people say.
If I can jump in as well, this is a topic that interests me. I co-authored with Cole Durham a 100-page chapter in a book by Jim Saratella about definition of religion. It's a difficult question, and there aren't simple answers. And certainly this question of religion as evil, that I think if you take religion seriously, we'll also take evil seriously. I think some of those cases that you bring up might get weeded out through a definition of religion, say like a sincerity. That would, I know many countries have used that to weed out, like the Church of the Flying Spaghetti Monster. They say, oh, this is a joke religion. It's not intended to be a religion. It's meant to be a joke. So if it is sincere, it passes a sincerity test, right? And then there's the question, the one interesting question with religion is sort of how broad do you be? Is sort of the presumption of innocence type problems. Is it better to have one religion that is evil that's included as opposed to not letting in others? Because I think one thing I'm skeptical of, and I know sort of many people who are sort of politically conservative with a small c, is the power of government to be the one deciding. I've worked enough in parts of the world where, in Russia, Catholics are seen in some places and in some media as sacrificing babies, right? Everyone knows it. Of course, everyone knows it. And so once you entrust the government into determining sort of how good your beliefs are, that would worry me.
You want to get on the microphone, Mark? That'd be great.
Thanks very much to the panel for all of the presentations. I'm looking forward to reading the papers a lot. My question is for Professor Bradley about lemon. And the question is a kind of a somewhat maybe boring doctrinal question, but why hasn't this happened yet? I mean, it could have happened in American Legion, and you had this weird holdout from Gorsuch and Thomas. It could have happened in Town of Greece versus Galloway, and instead they just sort of ignored the decision and said, no, this is a different sort of situation involving a historical test. So it seems like it's always supposed to be happening, and it never happens. Is it just, what's going on?
Well, I wish I knew, Mark. But I think part of the answer, maybe most of any serious answer, would have to deal with psychological and political matters about which I claim no, expertise. I mean, I can look at it analytically and read the cases, and I think I would say, Mark, you didn't listen to a word I said. It has happened, okay? We haven't had the formal requiems yet, but they're doing the autopsy as we speak. So that's part of an answer analytically. Now, why don't they do it? Now, part of it could be the Fulton problem, the Barrett-Kavanaugh question. Well, if we do get rid of it, what then? And I think there is an answer. I offer an answer, but maybe it's not quite so apparent to the court what the alternative is. And it may be that I think even the members of the court that for the moment we're talking about, who are prepared to throw it overboard and probably have thrown it overboard, like say Sam Alito, I think he's really somehow still captured by the secularist paradigm in a way he can't entirely shake free. So what does he do with the Bladensburg Cross? Now, maybe in some respects it's the path of less resistance, or there's an economy, I wouldn't say it's an economy of argument, but it's an economy of premises to say, we're keeping everything that's on the plate, however much of a potpourri or a stew it is, but here's what we're going to do. We're going to say the relevant purpose is not the purpose of those who erected it, but the purpose of keeping it up. And you can have crosses that started religious and now have been kind of bleached of their religious content, sort of like whited sepulchres. So for Samuel Alito to take a whited sepulchre route to say, well, we can still have a secular legislative purpose and we can have the Lemon Test, and he formally at least affirms those parts of the Lemon Test, but as they say, turns the cross kind of upside down. So he doesn't need to do that and he shouldn't do that. But why does he do that? I think in Alito's case, and to some varying extent, even the rest of the justices can't break entirely free. They've got it in their heads. To me, it's a truly unintelligible proposition. But I think they've still got it in their heads that there's something in the following norm which they need to retain. Norm, which first appears in Epperson in '68. You can see the antecedents of it in Everson, but the state must remain neutral between religion and non-religion. Okay, I think that's unintelligible, but Helen had to have me come back and explain why I think it's unintelligible. But I do think that they've got that in their heads, and you don't just walk away from that, even if the bodies of prior cases are strewn all over the ballroom floor.
I know this is end time, but Steve, you had a question, and it's okay if we run like 5 minutes late, right? We've been so good this afternoon. Joanne, could we do that?
Yeah.
We'll have,
Okay.
okay. Do you want to ask the question, Steve,
Yeah.
and we'll just go another 5 minutes and then
It's
we'll.
time and a half, right, Helen?
Yeah, totally.
Okay, well, so I thought all the presentations were excellent, but this is also kind of a common question for Jerry. So I'm pretty sympathetic to overall what you're doing with the paper, and I always hate to disagree with you, but I had two disagreements. One is in pursuit of a larger agreement, I think, and the other relates to some of what's being discussed here. So the disagreement in part of a larger, you said that the first prong of the Lemon test is pretty much gone anyway, the secular purpose prong. And that might be true if we're just thinking about Establishment Clause cases dealing with like school aid or something of that sort. But it has always seemed to me that the larger significance, and I don't know if this can all be attributed to the Lemon test itself, has been a sort of a secular understanding of government in general. And that, I think, is pervasive and has not gone away by any means. And I think you see that a lot in other areas. Maybe, one clear one would be, say, in the old same-sex marriage or traditional marriage law decisions, where it was always just taken for granted by everybody that no religious reason could be given in justification of any law. And that's pervasive, I think. Now, the reason why I think that's in pursuit of a larger agreement is it might be that officially eliminating the symbolism of the Lemon test would help to dislodge that. But it seems to me that's a huge concern, that we can't just say that's already gone. The other part, though, is, this is a disagreement, I think, is you say, I think correctly, that the court's gone way beyond what establishment really means, non-establishment really means. But in saying what it really means, it seemed to me, when you quoted the justices like Black and Frankfurter and so forth from those early cases, who admitted that they were going beyond it, they seemed to understand that it meant establishment meant something, officially establishing a church, as the church. I would say that's what it really means. But when you say what would replace it, you talk about no religious preferences and so forth. And it seems to me that goes way beyond what establishment really meant. And it gets you into all of the problems that Hadley Arcus and other people are talking about, and could be used to do just as much mischief as the Lemon test itself is doing. So I'm just wondering why you make that move, which seems to me ill-advised for your own purposes.
Steve, you're the guy that was agreeing with me, right? Okay. Yeah. Well, I think there's much more to be said about the second of your 2 points about what would a norm of non-denominationalism, if you want to call it that, would look like. And I think I take your point that there's a lot to be said. I don't agree, I think, with your suggestion that it'll be as much of a hot mess as we have on our hands. I don't think that's true. But there'd be also a kind of dumb non-preferentialism and a smart, that is analytically sophisticated non-preferentialism. But that's a serious question, and it deserves more of an answer than I can give it. But as to the first point, I shouldn't be heard to say that I think it's already true that the court has abandoned the first prong, secular legislative purpose. I'm saying that it should be abandoned. And I say that for the same reasons why I think the top half of the second prong, no primary effective aid, because secular means, in this context, non-religious. And if you say it has to have a secular legislative purpose, I think implicitly what you're saying is the purpose can't be to promote religion. And that I do reject. So I think in this context, if I'm on the right track in suggesting, well, if you remove the secularist construct given to us by Everson, and then you have a world in which sort of even-handed promotion of religion, respecting religious freedom, is okay, and you can fund religious schools without discrimination, then I think what you want to say is that, well, a legislative or a state purpose to promote, encourage, and even aid religion is permissible. If we could agree on that, I don't really care what the language of the first part of the test is, but when they use the term secular in the first part of the test, what they mean is we're excluding exactly what I'm saying shouldn't be excluded.
Okay, I'm going to have to call time. If you go out to where the registration desk was, there's a door right near that, and there are snacks and a place for you to stand and chat. And we will come back in around 10 minutes. Okay, thank you very much. Thanks so much to the panel, much appreciated.